colleagues, and members of the public who are joining us in this meeting. My name is Tembani Pukula. Welcome to the continuation of our energy regulator meeting. It's still meeting number 289. May I take this opportunity to introduce the members of the energy regulator who are here so that we can calibrate their voices and know who is talking when they are talking. I will start with the Deputy Chairperson of the Energy Regulator and the Chairperson of the Human Resources and Remuneration Committee, Ms. Zandile Mpungose. Ms. Mpungose.
Thank you, Chairperson. Thanks, everyone. And greetings to the stakeholders who are following the proceedings. Thank you, Chair.
Thank you, Ms. Mpungose. Next is the CEO of NASA, Advocate Nomalanga Stole.
Good afternoon, Chairperson, members and members of the public. Thanks.
Thank you. We also have the regulator member primarily responsible for piped gas at NASA as well as electricity regulation, Ms. Nomfundo Maseti.
Good afternoon, Chairperson and the members, and good afternoon also to the stakeholders and members of the public observing these proceedings. Thank you.
Thank you. We also have the Ms. Zakitis Spear, the chairperson of the Audit and Risk Committee and member of other committees within NASA. Ms. Spear.
Good afternoon, Chairperson. Good afternoon, everyone on the call, and also good afternoon to the members of the public joining us today. Thank you.
Thank you, Ms. Spear. We also have the member of the chairperson of the IT Governance Committee, Mr. Pungai Sibanda. Mr. Sibanda.
Good afternoon, Chair, colleagues from NASA and members of the public. Thank you.
Thank you, Mr. Sibanda. And last but not least, we have the regulator member primarily responsible for petroleum pipelines regulation at NASA, Mr. Muzuvugile Mkhize. Mr. Mkhize.
Good afternoon, Chairperson, all in attendance, as well as the members of the public following the proceedings through the various live streaming platforms. Thank you.
Thank you, Mr. Mkhize. Colleagues, members of the public joining us today, we are now on item number 3, which is the approval or adoption of the agenda. May I check with the regulator members if there's any agenda item that they would like to withdraw, modify, or change? And if not, may I request the members of the energy regulator to raise their hands to indicate that they are in favor of adopting this agenda? We've got Mr. Sibanda, Advocate Sitole, Ms. Mpungose, Ms. Maseti, Sibia, and Mr. Mkhize. Thank you. The agenda is adopted as presented. We now are going to move to item number 4, the declaration of interests. Any interest to declare verbally, please raise your hand. I do not see any hands, but I do want to indicate that I do not have the pecuniary interest as stated in our National Energy Regulator Act on item number 7.2, which is the approval or the consideration of the NOAA Group trading license. But as it has been customary, I do not participate in those decisions. So I excuse myself so as to never bring the energy regulator into disrepute, only because this is a trading license and I also had a trading company. So I make that verbal declaration. I will also complete that in the declaration forms. If there is no other verbal declaration, may I request the members to ensure that they complete the declaration forms that have been attached, and we will then move on to item number 5. Item number 5 is the report from the chairperson of the Petroleum Pipeline Subcommittee, Mr. Muzuvugile Mkhize. Mr. Mkhize, we have 3 items on the agenda. May you take us through all of them, starting with 5.1.
Thank you very much, Chairperson. Under item 5.1 is the updated frequently asked questions on the tariff methodology for the setting of tariffs for petroleum pipeline facilities, for which is version 8. We're requesting the energy regulator to consider and approve the updated frequently asked questions, the FAQs, on the tariff methodology for the setting of tariffs for petroleum pipeline facilities. It's attached, which is attached to as Annex A. The matter was discussed by the EPS, which is the Petroleum Pipeline Subcommittee, on the 10th of December, 2024. And then there were improvements that were made as tabled under 6.1 in tables 1 on page 4 of 129, the green page. Part of the recommendations or guidance provided was that they needed to expand on the background so that this is not only helpful to licensees who want to apply for tariffs, but also gives prospective licensees an idea as to what to expect and to look at the whole process if they are thinking of even applying for a construction license, to then say if they want to play in this sector, this is how the tariffs are set or determined. I will leave it at that, Chairperson, because I take the matter as read, and it's on page 7 of 129 under paragraph 14.1, where the recommendations are that the ER considers and approves these FAQs attached to as Annex A, noting that they come at the back of the review of these tariff methodologies. Thank you.
Thank you very much, Mr. Mkhize, for the brief introduction of the matter. Members of the Energy Regulator, there's a matter in front of us. Any questions, comments? Ms. Chauke, I see your mic is on. Members, if you have any questions, please indicate by raising your hand. I don't see any hands. Mr. Mkhize, I just wanted to ask on page 20 of 129, 7.2, the line fill. I'm not sure if there are words that are missing in that where it says the line fill is to be valued at lower of cost or net, lower of which cost, or and this is a familiar term in the petroleum pipeline industry. It's understood what it means. May you assist?
This is page 20, Chairperson.
Yes, paragraph 7.2.
I'm just getting there. Pardon me, I'm using the same for both the convene and the connection to this meeting. 7.3, receivable is
7, line fill. What I don't understand is the part says lower of cost, because the initial point was it is going to be valued at the cost of the product. So are we saying lower?
Yeah,
maybe if you can just
I think that there should be changed to lower of cost of acquisition of the product or net realizable value.
Okay.
Yeah, it should. Yeah, with the team is going to change it accordingly.
Thank you, Mr. Mkhize. I see Ms. Bia has a hand up. Ms. Bia, you have the floor.
Thank you, Chair. Chair, maybe let me help, because it's an accounting term. We call it like that. It's lower of cost or net realizable value. What we are saying is that something can cost, let me say a car. You bought it at 10,000 Rand, but today, when you bought it 5 years ago, the net realizable value, when you sell it, now you can only sell it at 5,000. So that is why they actually use that value like that, but it is called lower of cost or net realizable value. It's correct as it is written. Thanks.
Thank you. Thank you, Mr. Bia. I suppose I have to accept the terminology of this, but I still like that lower of cost of product. But I think cost of products and cost in this context should mean the same. But thank you for that clarification. Thank you, members. I'm clarified. Any other questions? Faye?
Chairperson, thank you. For the record, am I to take what the correction given by Mr. Mkhize or the clarification given by Ms. Sibia in terms of matters arising and the minutes?
I think, Faye, for the ease of reference in this, so that no other person who doesn't know this, they can just put the law of cost of product in brackets, but law of cost is understood in these terms. Thank you. Thank you. Members, I think Mr. Mkhize had read out the recommendations. They were on page 7 of 129, Mr. Mkhize.
Yes.
Yeah, page 7 of 129, recommendation 4.1, that we approve the updated FAQs on the methodology, which are attached as Annexure A. May you please raise your hand, members, to indicate support of this approval. I've got Mr. Mkhize, Mr. Sibanda, Ms. Mbungose, Advocate Sithole, Mr. Bia, Ms. Maseti. The FAQs have been approved. Mr. Mkhize, you can take us to 5.2.
Thank you, Chairperson. Under 5.2, this is just the confirmation of approval by round robin, which was it's an application by Noah Ambrose Park Oil Terminal, P2I Ltd, NAPOT for short, for the second amendment of the conditions of its 2 licenses issued for the construction of a storage facility and pipelines in Ambrose Park, KwaZulu-Natal Province. This was occasioned by the impasse that is there between Transnet and NAPOT regarding the acquisition of the lease to build these facilities on. Hence, they've then requested that they be given an extension to be able to do that. It is contained under purpose under 2.1 in terms of what the request to approve what entailed. I won't belabor the point because all the members have had sight of this and also given the stamp of approval. Thank you.
Thank you very much, Mr. Mkhize. Members, I think there's nothing to discuss in this one. May we please just indicate by raising our hands that we are happy to note the round robin approval. Mr. Mkhize, Mr. Bia, Mr. Mbungose, Advocate Sithole, and Mr. Sibanda. That has been noted. Mr. Mkhize, we have you on the next item.
Thank you very much, Chairperson. The last one is on the minutes of the Petroleum Pipeline Subcommittee meeting number 189, which was held on Wednesday, the 6th of November, 2024, via Microsoft Teams. I'll take the minutes as read and not necessarily highlight any specific matter. I will stand ready to respond to any questions, take any comments or guidance from the members. Thank you, Chair.
Thank you, Mr. Mkhize. Members, any questions, comments, or points that you would like the member to clarify? If none, members, may I request that you indicate by raising your hand that you are in support of noting these minutes. Got Ms. Sibanda, Ms. Mbungose, Ms. Maseti, your mic may be on.
Yes, Chairperson, because I'm struggling. Yes, I just want to say that I approve, Chair. Thank you.
Thank you. Ms. Advocate Sithole and Ms. Mkhize and Mr. Spear, and I saw Mr. Sibanda. So the minutes are noted. Thank you. Mr. Mkhize, anything you would like to add before we move on to the Pipe Gas Subcommittee?
Nothing really except to say that just the committee we should have the Transnet pipelines tariff application serving before this committee in the next meeting. Thank you.
Thank you, Mr. Mkhize. Mr. Mkhize, that is also one of the bigger decisions that NESA has to make. So I think if we could also ensure that before it comes to the committee, the rest of the members have been properly workshopped. Thank you.
We'll do so.
You got that, Mr. Mkhize. Thank you. Members, we are now going to move to item number 6. Item number 6 is the report from the chairperson of the Pipe Gas Subcommittee. This is done by Ms. Nomfundo Maseti. Ms. Maseti, you have the floor.
Thank you, Chairperson. Chairperson, the first report under the Pipe Gas Subcommittee is the application submitted by Petro SA Ltd for a maximum price of gas for the period starting from April 1st, 2024 to 31st March 2027. Chairperson, this is the first time that Petro SA applies for a maximum price as it is a new entrant into the gas trading business. So I just wanted members to take note of that in terms of maybe coming across some challenges that we encountered in the application itself for compliance purposes. However, the some of the issues were sorted out, and the matter served before the PGS. Now, for the energy regulator's decision today, the committee is requesting that the regulator approves the maximum gas price that is applied for by Petro SA. Table 1 of the covering submission shows the components of the maximum price application, the cost of gas as indicated therein, which is confidential, and the trading cost pertaining to the assets that they are using for trading to contribute on that, as well as the profit component on the energy component, the molecule itself, as required on the regulations, regulation 4 sub 4 of the piped gas regulations. And this is also in line with the methodology that was approved by the energy regulator. Chairperson, there were no substantive issues raised by the subcommittee in bringing this matter before the energy regulator. But if the energy regulator can note table 3 as well, where there is an assessment done by the energy regulator as well as Petro SA, and you will see that the difference is very small. It's about 1.65% difference between the two, and really that difference is caused by the calculations of the trading cost as well as the profit component, and the energy regulator approved what Petro SA has requested. Chairperson, just to take you to the decision, and the decision is on paragraph 14 of the covering submission, where the energy regulator is requested to approve Petro SA's application for a maximum price of gas, and that approval is for the period starting 1st April 2024 up until March 2027. The table of what needs to be approved is attached to the person as part of this decision. All of the other items that the regulator needs to approve is that the price excludes VAT, and that Petro SA will be subjected to Section 22 of the Gas Act in terms of differentiating on the price that is charged to its customers, and that the decision of the energy regulator becomes effective on the day that the matter is approved by the regulator and for monitoring purposes, and will remain in force until a new maximum price is approved. And Petro SA is required to apply for a new price at least 4 months before the expiry of the currently approved maximum price. Thank you, Chairperson.
Thank you, Ms. Maseti. Members of the energy regulator, any questions, comments, points to be clarified? If none, because I do not see any hand, Mr. Span.
Thank you, Chairperson, and thank you to Ms. Maseti. Chair, I do support the recommendation. I just have 1 or 2 comments, nothing critical, but under market analysis, starting from page 9 of 23, I see that we've identified a potential market relating to gas to power uses. I think in future assessments of the adequacy of competition, the last that we did was in 2022. I think in future assessments, it might be useful just to delve deeper into this potential market, because I think in this application, we've sort of done a cursory assessment, but then it might be necessary in future just to go much deeper into that. But also in this particular application, it might be necessary just to talk about the geographic dimension of this potential relevant market, because we just talked about the product dimension. So market definition is never complete without the geographic dimension. So I think we might need to just say something, even if it's not conclusive. We don't actually need to be conclusive on it, but it might help just to have a view on what we think the geographic dimension is. And then I wasn't too sure on our assessment of the barriers to entry on paragraph 3.9 on page 11. It's not clear to me whether we are assessing barriers to entry at the level of the applicant or at the level or at the downstream level of its customers. If you can just have a look at that, especially paragraph 3.9.3, and just make sure that we are clear what level of the market we are assessing in terms of the barriers to entry there. Otherwise, that's all from my side. Thank you.
Thank you, Mr. Sibanda. Ms. Masetti, any inputs? Because I think the one about 0.9.3 is just to correct and align, but on the one before that around the geographic and other matters that need to be assessed, may you please provide any responses?
Thank you, Chairperson. I will just confine the response on the two. Chairperson, the one on the geographic market, I think it is a relevant point, and we take the point. Otherwise, it will be difficult to conclude on a market without that dimension on the geographic scope of competition, so that we can see whether by approving the maximum price, we have made a proper a case on the prerequisite that is stated on section 21(1)(p), that if there's not enough competition, then the regulator must approve the price. So I think it's a good point that Mr. Sibanda made, and we will definitely cover the geographic scope of competition to see if we're making the decision properly. Louise will just come in because we are also doing the annual reviews just to test if there are any substantive developments on competition because of these new entrants, and Petro SA also being the new entrant in this market. And there is no finding of adequate competition, just to give the members comfort for purpose of the decision, that when we look at the national geographic market, there's not been any finding that competition at this time is adequate in the gas market from a national scope of the geographic market. Louise may just come in on one or two points there to supplement. The other one, Chairperson, on the barriers to entry, may I also just request that Ms. Du Plessis just come in there, clarify. Those are the two. Chair, thank you.
Thank you very much, Chairperson and Mr. Sibanda, for the comments. Yes, on the geographic scope of the market, we will enhance it. We might not be able to conclude with definitively conclude on the relevant geographic market, but I can confirm that because if Petro SA does in fact enter into this level of the market, which it's not yet clear because we're not yet sure about the exact customers that they will serve serve. But if they do, then they will be the first entrant, and therefore competition will be inadequate, whether the market is defined as regional or national. So I can confirm that. On the issue of barriers to entry and expansion, we will enhance it. I think we were looking at it from the level of Petra entering as a trader, and the barriers to entry at that level is still the issue of inadequate volumes of gas, and the fact that there will be more gas brought in might slightly reduce those barriers. So the issue of inadequate volumes of gas is applicable to on all levels, on all trading levels of the market, and therefore it is applicable, but we will just have a look at it again to see if we need to tweak the wording to make it more specific. Thank you.
Thank you, Louise. May I check, Mr. Sibanda, you comfortable with the fact that this would be looked at, and the other response around the being the first entrant, that obviously there would be inadequate competition?
Yes, Chair, I'm very much comfortable, and I'm also covered by the responses. Thank you.
Thank you. Thank you. Colleagues, members, may I then request that we then look at item 14.1 as read out by Ms. Maseti. We got 14.11, 14.12, 14.13,
You have a call from +278.
It's your mic, Ms. Maseti, and 14.15. If we could indicate by raising our hands that we are in support of approving this. I've got Mr. Mkhize, Ms. Maseti, Mr. Sibanda, Mr. Bia, Ms. Bungosa, and Advocate Sithole. Thank you. We have the approval. Ms. Maseti, you can take us through to the next item, 6.2.
Thank you, Chairperson, and apologies. I had to be in the car to get good network. Thank you, Chairperson. The second matter from the Pipe Gas Subcommittee is the application submitted by Kwande Gas Pty Ltd. It is also a trader, Chairperson, entered the market 2 years ago. So it is still one of those companies that we are monitoring whether the entry into the market has been successful, and that there are no barriers to entry that are impeding the expansion of this entity. With the finding of inadequate competition, Chairperson, when the markets were defined here, whether the market is confined to a localized market or to a regional or national market, competition state is still not at a workable condition level. So with that, the energy regulator proceeded to do the assessment of Kwande Gas application for a maximum price. I would like to draw the attention of the energy regulator to table 1. Table 1 being the table that the energy regulator is requested to approve for the maximum price that Kwande Gas has applied for. Again, Chairperson, I draw your attention and the members' attention to the components that make up this maximum price, being the cost of gas at which Kwande Gas pays in procuring the gas directly from Mozambique. Secondly, the trading cost that enable Kwande Gas to trade in its business. Trade in gas, and then the third one being the profit component calculated using the methodology that was approved by the energy regulator, which then gives us the maximum price of 127.52 per gigajoule per annum. Chairperson, there were no serious issues that were raised by the Pipe Gas Subcommittee in respect of this application. Just in terms of the forecast there, it's on table 3 for the adjustments that need to be made for the cost of gas, if the members can take note of that. And the members were also taken through the table 4 just to show how the profit component was calculated in terms of the methodology. And in terms of the trading cost, again, table 6 deals with that. With the information that is confidential having been highlighted. Now, I would like the members to just note table 7, which then shows how, the calculations done by NERSA in comparison with the calculations that were done by Kwande Gas. And you will note there the difference between these two calculations, very minimal. With that, Chairperson, I would like to take the members to the decision that is sought, and the decision is on paragraph 14. The energy regulator is requested, trying to get to the relevant paragraph, is requested to approve the maximum gas price for Kwande Gas. The maximum gas price is 127.52 per gigajoules. The period for this price is 1st July 2024 up until 31 December 2024. And this is in terms of the quotas that were calculated, Chairperson, since we had information for the adjustment for the quota, so that it brings predictability and certainty to the customers that will be charged at this price. And then on 14.12, the energy regulator is requested to approve the maximum gas price that will be adjusted from 1st January 2025 up until June 2025. And that is also based on the contract that this licensee has with its suppliers of gas from Mozambique, which are adjusted based on PPI, that the maximum price that is approved excludes VAT. Discounts are allowed, but they must be granted within the parameters of Section 22 of the Gas Act. And the energy regulator's decision of today shall be the effective date of when the decision was taken, and that maximum price will remain in force until the energy regulator approves a new price. And Kwande is also required to apply 4 months before the expiry of the price that the energy regulator approved. Thank you, Chairperson.
Thank you, Ms. Masetti. Ms. Advocate Sitola, I see your hand is up. Any questions?
Apologies, Chair. It's a lingering hand.
Oh, okay. Thank you, Advocate Sitola. Members, Advocate Sitola has put, Ms. Masetti has indicated what the submission is about and the recommendations that she has made on item 14.1. But before we get to that, any questions, comments, points to be clarified? Mr. Spanda?
Yes, Chair. Thank you to Ms. Masetti. Chair, I just wanted to understand in terms of the second recommendation to approve the maximum gas price, but adjust it using a US PPI. I was actually looking for the reasons for that, but I couldn't quite get why we using the US PPI. I know that the prices are probably quoted in US dollars, which brings me to the second question as to the forecast exchange rate, because I think for transparency purposes we may want to just indicate what forecast exchange rate we are using. And then lastly, the last recommendation to, well, this is a standard thing that we have probably in all the applications, where we request that the applicant must apply at least 4 months before the expiry their current maximum price. But I always wonder what is the consequence of not complying with this requirement, because hardly in most instances licenses just do not comply with this, but we seem to not what's the word, but yeah, it seems to be a perpetual issue where licenses just apply after or rather not comply with that particular requirement, and I'm not sure what the consequences of not of doing that are. It's not clear to me. Thank you, Chair.
Thank you, Mr. Sibanda. Ms. Masetti, you have the floor.
Thank you, Chairperson. Chairperson, I would like to start with the last question from my colleague, Mr. Sibanda, on the consequences of not complying with the requirements to apply within 4 months. Chairperson, we never had this part of the decision before. The 4 months is in the license conditions. As you would note that Section 21 of the Gas Act, which deals with prices, it is a license condition. Now that condition has not been complied with by the by some of the licensees. Some of the licensees they rely on the recommendation that states that the price that is approved by the regulator will remain effective until a new price is approved. And that had unintended consequences. One is where sometimes they would not apply in time. That's the first one. The second one is that this part was introduced, Chairperson, I think in 2015. That was meant to avoid instances of non-compliance, where, for instance, the licensee would have applied in less than 4 months, say apply in 2 months, and therefore NERSA is still processing the application. And in between, now the licensee will say, well, the application is before the regulator is still considering it, and therefore they don't really know what price or tariff they are supposed to charge. Then we introduced that to say that it will be effective until the energy regulator approves a new tariff or a new price. Now, to close the gap, because sometimes they apply very late, to close this gap, we thought that let's take what is in the license conditions and bring it here as a decision so that it will make it easy for the energy regulator to enforce its decision to the extent that there is non-compliance. So it is the first time that we now include this aspect of on the decision that is made by the energy regulator. Thank you, Chairperson. I would like to invite Mr. Ngumalo to respond to the issue of the recommendation. The recommendation pertaining to the adjustment of the price using the PPI as the executive manager to respond specifically on that question that is asked. Thank you, Chair.
Thank you, Ms. Masetti. Mr. Ngumalo, please come in.
Thank you, Chairperson. I think just to confirm, as Mr. Sibanda did touch on it, that really the gas prices are predominantly or mainly denominated in US dollars. And I think that then accounts for the reason why the PPI used is actually the US PPI. But I think we do take the point that Mr. Sibanda is raising. I think going forward, we will try and basically look into it to see whether maybe we can just, there are any standards or trends globally anywhere where we can maybe, align with a different approach to it. But currently, really, it's based on the US PPI, simply for the reason that it's dollar denominated. Thank you, Chairperson.
Chairperson, just to add.
Yes, Ms. Masetti, please go ahead.
Thank you, Chairperson. Chairperson, it is the only trader here in gas that makes an adjustment based on PPI. It is not in the norm of the industry here in South Africa that there is this adjustment. The only reason that the adjustment is using the US PPI, it is because of the contract that this licensee has with its supplier of gas, of which supplier is from Mozambique. This is the gas that was previously allocated to a state-owned entity in Mozambique. Now, to take that gas and bring it to South Africa so that they get value out of that gas instead of it being utilized in Mozambique or consumed in Mozambique, they then looked at an alternative market for them to derive value out of it. Now, the contract, unfortunately, is based on the adjustment that is the US one. So if that is not done, or we don't use what or compensate in accordance with what is in the contract, yet the methodology says it is a cost plus methodology. It is for that reason that we accept it, because the methodology is a cost plus, and therefore it is affected or influenced by the terms of the contract for us to be able to compensate adequately. And that is the reason for this one, Chair. Thank you very much.
Thank you, Ms. Masetti. May I just check, Mr. Sibanda, are you covered?
Chair, I do take the point if it's a contractual issue, but it just didn't make sense to me that simply because the prices are US denominated, then we should adjust them using a US PPI. It doesn't necessarily follow, but if it's a contractual issue, I accept, Chair. Yeah, then the other issue was just the forecast exchange rate, which is not indicated, Chair. Thanks.
Thank you, Mr. Sibanda. Mr. Murati, you may want to mute. Your mic is on. With that, Mr. Sibanda, are you fine to support? But I think we, as you have indicated, we may just require more crisp explanations for some of these things. But are you comfortable with what has been given?
I am, Chair. Thank you.
Thank you. Members, we have the recommendations there on page 15 of 34. Ms. Masetti read them out. May I request that you raise your hand to indicate your approval? But Ms. Masetti, Mr. Sibanda, Advocate Sithole, Bungose, Mr. Bia, and Mr. Mkhize. Thank you. The Kwande gas maximum price has been approved. Ms. Masetti, we are done with item 6. We are going on to item 7, the electricity report, which we are going to continue. At this point, I would like to ask Ms. Mbungos to chair the session, as this is the item that I declared that I would not want to participate in. Ms. Mbungos, if you could take over from, yeah?
Thank you, Chairperson. Yes, members, we've got item 7.1, which is an application for an electricity trading license by NOAH Group, Trading Pty Ltd. I would like to hand over to Madam Masetti to present the item. Over to you, Madam Masetti.
Thank you very much, Deputy Chairperson. Deputy Chair, what is before us today is the application received from NOAH Group Trading Pty Ltd. The subcommittee that is delegated by the energy regulator, the electricity subcommittee, has considered this application, and it is requesting that the energy regulator approves the trading license for NOAH Group Pty Ltd. This is an application, Chairperson, that was received in April 2024, and And in this case, or this application, is pursuant to a contract that was entered between NOAA as well as the generator of power, and with which is Wind Garden Pty Ltd, for a 20-year period. Chairperson, there is no substantive issues really that were raised at the ELS. The issues of compliance by this applicant in terms of the rules and in terms of the legal requirements, it has met all of that, and the committee was satisfied, and therefore the committee is now requesting that the energy regulator approves this license. Just for the issues that were raised on the committee, I just want to draw your attention to Table 2, which summarizes all of the issues that were raised, and all of those issues were clarified and responded to. Now, if I were to go to the decision that is sought from the energy regulator, the decision is summarized on paragraph 6 of the submission, and the regulator is requested to approve that NOAA Group Trading Pty Ltd be granted a 20-year trading license for it to trade in electricity, subject to the conditions that are attached here as Annexure E. And also to note the 20-year generator power purchase agreement between this applicant as well as Wind Garden Pty Ltd. Also to note the 20-year master customer power purchase agreements between Energy NOAA Group Trading and Netcare Hospitals. Also to note the tariff in the master customer power purchase agreement between NOAA as well as the network, the Netcare Hospitals, Netcare Hospital Pty Ltd. Also, the energy regulator is requested to note the tariff in the generator power purchase agreement between NOAA Group Trading as well as Wind Garden Pty Ltd. And lastly, to approve the reasons for the decision that is sought. Thank you, Chairperson.
Thank you, Madam Massetti. Members, we've got an item for approval. Do we have one member who's got a question or comment on the item by a show of hands, please? Yes, Mr. Sibanda, please go ahead, sir.
Thank you, Chair. Chair, I'm comfortable with the recommendations. It's just the one concern that I have regarding Eskom's objections, and it's not the first time that Eskom is objecting to these types of licenses, and I think we probably need to. I don't know how we resolve this matter, Chair. Maybe through guidelines or some kind of clarification, so that it's resolved once and for all. Because I don't think it doesn't look good to always have these types of, well, it's within Eskom's rights, obviously, but I think from our side, we probably just need to have some guidelines of sorts or some other type of clarification of this matter, Chair. That's the only comment really that I have on this. Thank you.
Thank you very much, Mr. Sibanda. Madam Massetti, there's that guidance or proposal from Mr. Sibanda, his concern with regard to the constant objections when there are trading licenses being applied for, to say as a regulator we need to find a permanent solution on how best to address this, and either in way of guidelines or any other way, but I think it's a matter for consideration. Really, I don't know if you've got any comment or you'd like to respond to it, but it's not necessary really.
Chairperson, Deputy Chairperson, I don't have anything to say on this. It has been raised before, and the division has indicated that it is developing guidelines to make sure that the issues that led to the objection are clarified. So whether that will put an end to the objection is something else. If one also will consider the source of that objection from Eskom's side. However, in terms of us doing what we need to do to clarify for everyone and ensure predictability on how we handle these issues in terms of the law, the guidelines or explanatory note, it will be considered. There is no objection to that proposal from Mr. Sibanda. Thank you very much.
Thank you, Madam Maseti. It's good that the team is already working on it. Members, we've got the item for approval. Madam Maseti has already read the recommendation as they appear on page 4 of 285 under 6.1 to 6.1. I think it's 6.1 until 6.16. If you are happy to approve the item, can you please indicate by a show of hands, please? Thank you, Madam Maseti, Ms. Sibia, Mr. Mkhize, Mr. Sibanda, Advocate Sithole, and Ms. Sibia. I'm also happy to approve the item. And thank you very much. I will like to hand over to Mr. Pukula, and then we'll carry on with the rest of the agenda. That is 7.2, and that is NTCSA's application for congestion curtailment to be a constrained generation ancillary service. Over to you, Mr. Pukula.
Thank you, Mr. Mpungose. Thank you, Deputy Chairperson. Ms. Maseti, 7.2 is your item. Please take us through.
Thank you, Chairperson. Chairperson, this is an application that was made by Eskom for or NTCSA for handling the problems or challenges with congestion in its network or the grid. So in terms of this application, they are requesting that congestion curtailment be considered as a constrained generation ancillary service. And they brought this matter to the energy regulator to make an assessment of it. Chairperson, just to indicate that the matter served at the committee, and the committee only has powers to recommend to the energy regulator for the final decision. Now, Chairperson, they are, although the committee has considered this matter, there are also financial implications should the energy regulator approves the request that has been made. Now, the issue of the financial impact of the request that is sought from us, obviously it will impact it will impact the components of the MYPD decision that was taken yesterday by the energy regulator. In particular, one would note that there were ancillary services cost that were included in the MYPD6 application. One of them being the primary energy cost that they've asked in the application under the NTCSA. So yesterday we did touch, for instance, on the issues of unbalanced energy. And when we touched on that issue, we had said that the amount that will be allocated for that will be will not exceed 650 million, if I'm correct, but the colleagues may come in and rectify if I have not cited the figure accurately. So that being said, Chairperson, it meant that we rejected the amount of over a billion rand that Eskom has requested in terms of that item in the MYPD. In addition to that, Chairperson, as we were processing the MYPD 6 application, we received correspondence from Eskom. In that correspondence, Eskom has indicated that the figure that it has applied for, which is above R1 billion, that figure is not final. There is a possibility that the figure may escalate. And with that possibility, is due to the fact that they are still undertaking some research, and it may actually be more than what it has requested. Now, how does this relate to the application that is before us? It relates to this because, as I indicated, there is financial implications if we allow that a congestion curtailment be recognized as ancillary service. It will mean that the cost associated with that curtailment, where there's compensation due to the generators that would not supply, the costs that are arising from that curtailment will have to be recovered from all customers that are connected to the transmission or benefiting from the transmission network. So if already we've raised the concern on unbalanced energy and also limited the cost to 50 billion rands, then the 7.5% that is indicated in this application would then pose challenges. The energy regulator, with this conflicting information and Eskom not providing a firm figure of what it requires, it makes it difficult for the energy regulator to take a final decision. With that said, Chairperson, although the electricity subcommittee has made its recommendation, I would request the energy regulator to allow the committee to properly make an assessment of this of these matters, align them properly with the MYPD 6 decision, and then Eskom, when it is then ready, it will then provide us with information that will assist us to make a proper decision. Chairperson, this is just some alteration or at least a consideration because some of the information came after the decision of the ELS was already taken. And it is important that I bring this to the attention of the energy regulator before the final decision is taken. Chairperson, I would like to take the matter back to you for discussion. Thank you, Chair.
Thank you, Ms. Massetti. Members, we have this matter in front of us. Any inputs, questions, comments? There doesn't seem to be any questions or comments of Ms. Massetti. My recommendation would be that if you look at the recommendation like 6.11, we are allowing this that there must be this curtailment, but what we want to put a stop to is that it would be paid for by consumers beyond what we have allowed for in the MYPD. And secondly, I think on 6.17, no, it's not 17, but we on 6.16 we are saying that they can do the expansion and do the things that would ensure that there's no need for this curtailment. And we have allowed yesterday, I think we increased the amount that we allowed for their capital expenditure to about 75 billion rand. So in our view, that should be enough. So I think we can make the decision, but stop the part where the customers need to pay for it. If the the bilateral agreements will be able to carry that cost, that's fine, as long as it does not affect the general customers. Would that not be a good compromise?
I think it will be, Chairperson, so that other customers that did not, I mean, the user pay principle, or those that will require expansion to cater for their needs, will to cater for their needs. If there is any constraint, they should be the ones that carry that out, and those are things that must be dealt with in the bilateral agreements. If we can make that clear in our decision, that will be fine, Chairperson. Chairperson, may I also, from the members of the Energy Regulator, not to necessarily pick on you, but if you can also state your views on paragraph 6.1.4 in respect of the amount that is set at 7.5%.
Chairperson, Ms. Massetti, for me, the issue of the 7.5% is I mean, if we are saying that the customers are not going to pay and the generator and its bilateral will have that agreement, for me, the issue then does not arise. We can even remove that, because it would be an agreement between two parties and they would pay for it. Because for us to set it at 7.5%, it was when we're assuming that the customers are going to pay and we're trying to limit the expense. So I would think that we need to remove 6.1.4. But I see there's Ms. Dorcas who wants to come in. Ms. Dorcas?
Thank you, Chairperson, and apologies for jumping in at this stage. I would just like to highlight to the committee. I can hear what is being proposed by the members, but I just wanted to highlight that the main purpose of NTCSA bringing this application to NERSA for us to be able to consider constrained generation as an ancillary service is because they are wanting to be able to cater for private IPPs that would suffer as a result of congestion curtailment. And so they are trying to enable that process to be able to compensate them, because already for public IPPs, there's currently no issue. So if the decision is taken and we are approving it at the exclusion of the private IPPs, I'm just afraid that it's actually not going to address what the application was intending to achieve. Because if we are not dealing with the private entities, then there is no need for NTCSA to actually make this request to the energy regulator. Thanks.
Thank you, Dorcas. I'm not sure if I understood what you mean, Dorcas, and how different it is from what we are discussing, but Ms. Massetti, if you could come in.
Chairperson, I'm also lost, because all that we are saying is that our duty is to protect consumers or consumers from paying for this curtailment. So to the extent that there will be an arrangement to curtail at a particular area, and that arrangement is made between the private generator with NTCSA, that is an arrangement that will be made by those two parties, but they must not make that arrangement on behalf of the entire consumers in South Africa. And therefore, the entire consumers must not carry the cost of that curtailment. That's the point that we are making. Hence, therefore, that's what we are saying. Hence, I then said to the members, is there a need for 6.1.4? Hence, I asked the chairperson on his views now on that 7.5%, because we would not set a threshold, because what are we setting it for? We are not trying to mitigate any harmful impact on the consumers. As we say, it should not be recovered from the consumers that did not necessarily cause the cost. That is the principle, Chairperson. I don't think that we are taking away what she is saying. I'm not understanding the point, maybe, that she was making. Thanks.
Thank you, Ms. Massetti. I see, Ms. Via, your hand is up.
Thank you, Chair. Chair, just to confirm, yes, then the contract will be between the two parties, but the question then arises, will it then not find itself back into, say, the system and then be paid for by a customer? So that is a question separately. If we don't put a cap, and then somehow it then comes back and be paid for by a consumer, are there means and ways of making sure that it will never at any point come and be paid by a customer? That's my question.
Thank you, Ms. Sibiya. I see Mr. Mkhize, your hand is up as well. Mr.
Thanks,
Mkhize?
Chairperson. Yeah, I'm a member of ALS, and I'm just a bit confused now because we had recommended the 7.5 in view of the assessment that was done in terms of the cost benefit. To say 10% will be high, let's leave it at 7.5, where we're still gonna be using these less OCGTs rather than just wait for this great expansion. So I just want to get clarity now from my side. If that is out of kilter with what was approved in terms of MYPD 6. Because I think this is where now, for me, if I understand you correctly, where the challenge is. Just want to get clarification there.
Okay. Mr. Mkhize, and let me start with Ms. Sibiya. Ms. Sibiya, this amount, this curtailment is now going to be paid by a generator that has a private power purchase agreement with a consumer. It is not going to ever come back to the customer base because that is their agreement. And the reason, to come to you, Mr. Mkhize, the reason that it was being allowed was that because they would be helping with the reduction of the demand and therefore the reduction of the OCGTs, then it is fine that we allow it. But in this particular instance, we've given ESCOM money to expand the grid. Secondly, we are saying that whether it's 7.5 or 18.8, it should not be part of what is being paid for the customers, and we should not be concerned about that. If the two parties can agree on what they are willing to pay each other, then we should be fine with that. I'm not sure if I've answered clearly, but Ms. Maset, you can come in and, yeah.
You've done it so well.
Mkhize,
It's in line with the decision that was taken yesterday, or even on the issue of energy unbalanced there. It is in line with that, even when we discussed it during the workshop, as to why it is not something that is desirable that other customers be paying for it. So it is very consistent what we are talking about and what we are proposing, Chairperson, with what was discussed in the workshop and also clarified in the decision that we have taken yesterday. Thank you, Chair.
Thank you, Ms. Maset. Mr. Mkhize?
No, I understand in terms of the alignment that we're seeking to have, and not burden the consumers with this, noting the decision of yesterday. Thank you.
Thank you, Mr. Mkhize. But colleagues, before I just go back, I always appreciate that someone with a different view, and where in case there's something that is blindsiding us, I still want to find out from Ms. Rakhala Kane if this decision is misaligned with what she understood. Ms. Dorcas.
Yes, thank you, Chairperson. Yeah, I'm also maybe as the discussion is continuing, I'm trying to align with the members, but at this point, for me, if the decision is to stay when congestion curtailment is implemented by the system operator and a generator needs to be curtailed, if it's a private generator, in terms of how they get compensated for that money, it needs to be a matter between the NTCSA and the private generator, and that money should not be made to be part of the broader customer base. I think that's what I'm understanding the members to be saying. So in terms of the application, then that would be the challenge. So I guess then it would mean that the energy regulator is rejecting the proposal by NTCSA, because the actual proposal from the NTCSA was to say, if the system operator curtails that private generator due to network related matters, we want to be able to compensate that generator, because they were curtailed for matters that are beyond their control. And also the capacity, I think the main argument goes to the issue of this congestion curtailment will be implemented as a result of having accommodated additional generation capacity on the grid. When that generation capacity is added to the grid, then there's a possibility of having this congestion curtailment. So what this application seeks to achieve is that, because now
we understand what the application seeks to achieve, and I think you have mentioned that. So your point is you are disagreeing with the fact that the regulator is saying that the grid that is there has been paid for by the existing customers, and they've paid in full for it. So if there's a private generator that wants to connect into the grid at the risk of being curtailed, that private generator must pay for that, not the other customers who have paid for the risk. That's the part you are disagreeing with. Mr. Khalakhalan.
Yes, Chairperson. Okay. So I wouldn't want to say disagree, but maybe let me allow Mr. Shozi to come in case I don't want to confuse the committee further. I can always come back.
The committee is not going to be confused further. I think the committee, all we wanted was to understand your angle. And your angle is this one that says that let the customers who have paid for the grid pay for a private generator that wants to supply a private customer. And all of that would be because they would let us not use the OCGTs and the other things. That's really the crux of this. Mr. Shozi, you can come in.
Thank you, Chair. Good afternoon to you and members. Chair, ordinarily, I would have loved the submission to be considered without any alterations, but I've listened to the members' concern, because when we took the first submission to the members through even public hearing and the workshop, the issues who pays for what and why customers have to pay, I think we had captured that on the submission. But now, when members are not comfortable with what is being brought forward, even the conditions that you have put in there are the conditions that came from the risk analysis that you have done, benefits versus the risk. So I would request that we take it back as we had recommended initially, Ms. Massetti, so that we can probably rethink around what members have said, than to alter the decision that we might have a challenge in terms of implementing. That should be my request, Chairperson, that we are allowed to take it back and engage with the ELS members from where the matter started and why we of the view that the customers, even the cost should be socialized, but not to alter the decision as is. Thanks, Chair.
Thank you, Mr. Shozi, for your suggestion. And I think, Mr. Shozi, the difference between when we discussed it then and when we're discussing it now was we had not given Eskom 75 billion rand to expand the grid, which is being paid for by the customers, which will enable these other generators to connect. But I am comfortable, Ms. Massetti, with not making the decision if we would, and there's something I never appreciate when I'm chairing, when I get notes and charts that are talking about the item. If you want to talk about the item, raise your hand. I have never stopped anyone from raising their hand. Ms. Rakalakalani, desist from sending charts. Raise your hand and raise your point. I've given you the opportunity because as a regulator, we want to make a proper decision and we are not going to stifle good inputs. We don't want to be blindsided. But let's not write notes here that are acting like what we are saying is incorrect. So, Ms. Massetti, may I ask through you if we are going to take this item back and really come back with it after having exhausted all of the areas. Thank you. Ms. Masset?
Chairperson, thank you, Chairperson. Really, just to start, even before I get there, just to start from a principal point of view, Chairperson, as I indicated at the beginning, the powers of the subcommittee are merely to recommend. That's what we have as a subcommittee. Then when the matter comes to the energy regulator, which is where the buck stops, the energy regulator is not here to rubber stamp. And also there are members of the energy regulator that are not members of the electricity subcommittee that is delegated to process. Whilst I have requested, Chairperson, that yes, the matter must go back so that we can double check the alignment and make sure that even the reasons are well aligned with the decision that is sought. I don't have a problem in doing so, Chair, but I think, Chairperson, as the Chairperson, you may find out from the members of the board if they are comfortable that the matter goes back so that we can then make sure that what the team is raising, at least the members would double check those things and there will be no risk at all for the energy regulator. That will be on that basis, Chair, that I will propose that it goes back so that we clear the risk, we've got a proper alignment, and the reasons are talking to the nature of the decision and the scope of the decision that is being sought today. Thank you, Chairperson.
Thank you. May I really strongly recommend members that I think it is what Mr. Shozi has also indicated, that if you look at the reasons for the decision, we were leaning towards socializing the costs, but now that we have additional stuff, we may need to just recheck our reasons for the decision. So may I request the members if you would indicate, in fact, if Ms. Massetti can indicate that she is happy to have this matter withdrawn and reconsidered, then I don't think that the members need to vote. Ms. Massetti.
Thank you, Chairperson. It can be taken back, Chair, to the committee.
Thank you. Thank you, members. So we'll take this one back to the committee and we'll bring it back with the reasons for the decision aligned to what we want to do. Members, we have gone for an hour and a half. We have one more, another hour and a half to go. I'm going to ask that we pick up speed from this item before we close the meeting. The consultation paper, Ms. Massetti, if you can just take us through it.
Chairperson, I'll be quick on this one. Chairperson, the consultation paper is on the concurrence with the Section 34 ministerial determination for the procurement of 400 megawatts of new generation capacity by eThekwini from independent power producers. And secondly, 100 megawatts of solar power, as well as 300 megawatts of natural gas. And this is a matter that was brought by the eThekwini municipality for the energy regulator to consider. Sorry, Chairperson, I'm trying to get to the relevant page to consider. And the matter has been considered, and all that is requested from the committee is for the committee for the energy regulator to note the consultation paper. So the matter has not been finalized for a decision. The subcommittee has powers to approve that concurrence or the consultation thereof on concurrence. But now here we just want the energy regulator to note that the consultation paper has been published, and that is the recommendation, Chair. Thank you.
Thank you, Ms. Massetti. This is really for noting. So members, it's not approval, it's noting. But I see but I understand the convene doesn't have noting. Members, any questions, comments? I don't see any hands. May I then request if we could raise your hand, colleagues, to indicate that you are happy to note what has been published for consultation. Got Mr. Mkize, Ms. Massetti, Ms. Sibia, Mr. Sibanda and Advocate Sithole. Thank you very much. And Ms. Mbungose, thank you. Thank you. We are done with the open part of the meeting. I would like to thank the members of the public who had joined us. Thank them for their time. I also want to make them appreciate that or when we have these discussions, we have them in a manner that is robust and we do not necessarily consider the decision-making process the sole province of the energy regulator. Yes, it will be, but we consider all of the inputs that we can get from all of the people who are here supporting the energy regulator. Thank you for your time. We will see you again in our next meeting that is scheduled. The meeting is now closed. Faye, you normally require a few minutes, so when you are ready, please indicate that you have sorted out your recording. Thank you.